There's nothing of that. I've just seen that there is some new filings that have been updated, we've got some new documents that have all been updated, so I thought let's have a look at them together. If you're new to my channel, I am a law student from Melbourne, Australia, and I like to look at different things, and in this case we're looking at the Katie Joy Without a Crystal Ball documentation from 7M, their case. So we have got some things here. So the first thing that we've got here, which is really interesting, is a substitution of counsel. So let's have a look at what this is. I don't know whether this is going to open properly for me or not. All right, so I've got to go to here and share a window, I think. As I'm using the new version now of this, and let's have a look. A window. No, info. Nope. Chrome. No, it's not a tab even. All right, let me find it. Hello, Tracy. How are you? I'll have to do it this way. All right, another way up. This may take me a little bit to get this all up, because there's lots of documents here. We're going to open with Chrome. And we're going to bring it over to this window here. I hope you're having a better day than me at the moment. I'm having a shocker of the day. Yeah, some new paperwork that's just hit. So there. Yeah, look, I'm having a bit of a shocker. Uni's paying hardball with my fees at the moment, so I don't even know whether they're going to let me study this semester yet, this term, so I'm not happy. So this is, first of all, this says substitution of counsel. So it says the counsel for the plaintiffs have moved firms from Dudley and Smith to Stackry Law. So she's obviously started her own company, and so when you have a change like that, you need to let the court know. So that's our first one. So that's nothing new. All right, so now we've got a new motion and a motion. So let's have a look what this one is. Give me a moment and we'll pull this up. There's a few here. All right. Now, it's funny because somebody has been talking about how they're going to win a certain lawsuit. But it's definitely going to be interesting. All right, I need to just open up another window. I've just come live. I didn't even sort this out, so I apologize for this. This in here and then across like this. All right, back to here. Right, here we go. This is, oh, no, that's not the right one. I keep opening up the wrong window. Hang on. I've got this. Do you know that? What's that one? Yes, oh, here it is. Notion, it's called a Notice of Motion and Motion. Which is quite unique. Well, no, not unique, but a Notice of Motion and Motion. Here we go. All right. So it's called a notice of motion and motion to compel. Two defendants. Katie Joy. Please take note that at 9 a.m. on Tuesday, 1st of August, 2023, at the Wright County District Court, 7M Films, Robert Sheen, Miranda Derrick, plaintiffs will bring on for a hearing before the Honourable Kari Willis their motion to compel discovery responses from the defendants. Plaintiffs will, and here do I move the court that the above stated time and place for the following, for a motion to compel discovery responses. The motion is brought pursuant to the civil law and will be based on files, records, proceedings herein and supporting memorandum and declaration in accordance with the rules. In accordance with the rules. Together with such additional oral and documentary evidences as may be presented in connection with the hearing of this motion. But Will, remember, didn't she share just recently that she was going to win her lawsuit, that there was nothing, that it wasn't going to go to trial, and that they were the ones that were bringing? I mean, there might be a filing. I don't know. This is what we're looking at. You're doing this with me live, so we're exploring this as it goes. So now this is the next document, which is memorandum. So I don't know, I just need the memorandum. Just hang on. Well, it's very interesting. I'm finding this all very interesting. 1122. I think this is the one here. Okay. Come across here to here. So she must be huffing paint or thinking if she gets... Well, it might be, but this also explains, Will, why we've had the sun or the carry-on of late. So this is the notice of motion to compel discovery documents. So this is defendants have failed to comply. Discovery. I'll see if I can make this bigger for you, and then let's see if we can get this bigger for you. No, don't want that. I don't want that. Let's try this one. And we go here, and we've changed this around. Now I can't make it any bigger. All right, I'll have to do it from here. That's better, isn't it? So they're filed to comply with discovery rules. Plaintiffs have attempted to meet and confer with defendants regarding their deficiencies in discovery. As defendants have refused to comply with discovery, plaintiffs' motion to compel discovery must be granted. All right, so here they list their civil procedure rules. So 3701B2 provides a party in discovery may move for an order compelling an answer, donation, production, or inspection. This motion may be made if a deponent fails to answer a question propounded or submitted under Rules 30 or 31. A corporation or other entity fails to make a designation under Rule 30.02F or 31.01C. A party fails to provide answers to an interrogatory submitted under Rule 33, or a party fails to produce documents or fails to respond that inspection will be permitted, or fails to permit inspection as requested under Rule 34. In Rule 37, motion to compel in non-producing parties burden to establish that the sought-out information is immune from discovery. Plaintiffs are entitled to an order compelling discovery responses from defendants. Plaintiff served its first set of interrogatories and first set of requests for production of documents to defendants on May 11, 2023. Defendants served their answers to the first set of discovery on June 12, 2023. Plaintiffs served their discovery deficiency letter upon the defendants on July 7. Counsel for plaintiffs have made a good faith effort to meet and confer with defendants to secure the requested information prior to making this motion to compel disclosures from the defendants. This is explaining why we've had this spiraling. This spiraling, this is why we've had this spiral over the last few days. Okay. So defendants' responses to discovery were deficient in 23 requests for production of documents and 36 interrogatories. Defendants failed to provide even one page in response to the plaintiff's request for production of documents. The specific challenges to discovery are outlined as follows. So this says, plaintiffs requested all documents which relate to any claims or defences alleged in the litigation between the party. Defendants objected as impermissible, vague, and protected by journalists' privilege. Plaintiff's request is not impermissibly vague, as specifically as to requesting documents which relate to this lawsuit. The defendant's defence is in the same. Further, a journalist's privilege pursuant to Minnesota Statute 595 and Cervantes v. Time does not allow anyone, even if they are a journalist, to withhold all information in a lawsuit for defamation. Defendants have failed to move the court for a designation as a journalist prior to this response to discovery and have not moved the court for this designation pending. Remember that the last judge said she could be. She didn't say she was a journalist. She said she could be a journalist, but that's not ever been defined. So what they're saying here is that they've never actually had the court to rule on whether they're a journalist and whether they could get the journalistic privilege. As the defendants have failed to protect any alleged privilege as a journalist in the past year of litigation, it is improper to use an alleged journalistic privilege to shield them from complying with any discovery in this action. Defendants are required by law to release plaintiffs' discoverable and relevant information in this lawsuit. She can still keep the sources safe, but still reveal the information. Does that make sense? As to defendants' specific objections under Cervantes v. Time Inc., defendants have provided no application of this case to the facts at hand for why journalistic privilege under Cervantes would preclude them from disclosing all information relevant to the claims and defences alleged by the defendants in this lawsuit. Further, Cervantes differs greatly from the case at hand. In Cervantes, the motion to compel was specifically brought forth to reveal the identity of the reporter's informants. Cervantes also differs from this matter, as it was undisputed that the article concerned issues of public interest. 2, the defendant was a journalist, and 3, the plaintiff was a public figure. All of these 3 issues are in dispute in this lawsuit at hand, and discovery relevant to defendants' claims and defences in this lawsuit is proper and must be disclosed. Similarly, defendants' claim of privilege under Minnesota Stat 595 also fails, as defendants have not specified how the statute applies with regard to either defendants or the specific discovery request. As stated above, the parties still dispute if defendants are journalists. The information was that of public interest, and if some or all plaintiffs are public figures. For the foregoing reasons, defendants must disclose the requested information. 2, plaintiffs requested all documents referenced in responding to the interrogatories. Defendants responded that they linked digital copies in posts. Defendants are required to provide all documents referenced when preparing answers to interrogatories. If there are specific posts, messages, emails, call logs, notes, etc., which were referenced, they must be disclosed. Defendants have not relied on any case law or rule which states they do not have to disclose documents they referenced in preparing their responses to discovery. As defendants have merely made a declaration that they don't have to disclose documents and have not included any legal reasoning, therefore, defendants must disclose all documents they reference in the responding interrogatories. 3, plaintiffs requested all documents referenced in responding to requests for admission. Defendants responded that they linked digital copies in posts. Plaintiffs' rationale for defendants' sufficiency in disclosures as it relates to responding to the documents referenced in responding to requests for admission is the same of that of request 2. Request 4. Plaintiffs request the defendant produce all social media posts defendants have made regarding 7M Films Inc. or their associates. Defendants did not object to this request, but instead stated they do not know what affiliates means. No way! And that defendants have asked plaintiff to provide copies of plaintiff's post already in its possession. Oh, no. Oh boy. Oh, gee whiz. As to the latter, defendant's discovery request plaintiff's to request is not relevant to the defendant's disclosures. All of plaintiff's claims in this lawsuit are based on defendant's post and associated behaviour, as the entire lawsuit rests on defendant's social media posts. Defendants are required to provide the same, despite plaintiffs sending defendants a preservation letter. Defendants have deleted, archived or taken down many of their posts regarding plaintiff. Defendants have further to continue to post about the plaintiffs. Oh no, really, Joan? Joan, wait till you... Oh, really? You mean it gets better? Oh, no. So if defendants have continued to post about the plaintiffs and this lawsuit on their social media platforms, plaintiffs do not have access to every post defendants have made about them, but each post defendants make regarding plaintiffs in this lawsuit are relevant to this lawsuit. Amber, if you wanted to ask, if you put a call out, I'm sure you'd get every single post. As the defendants claim that they do not know what affiliate means, the dictionary... The dictionary! Oh, what? That is shade. As to defendants' claim they do not know what affiliate means, the dictionary definition of affiliate is officially attach or connect a subsidiary group or person to an organisation. As counsel for the defendants have repeatedly stated, she has decades of experience in litigation, stating that they do not understand what the word affiliates means or how it is connected to 7M Films. He's not persuasive. Oh, is that a bird? Further, defendant's objection to affiliates does not preclude discovery of information as it relates directly to plaintiff's defense. Wow. I can't get over that. All right, request 5. Plaintiffs, I thought she was a journalist. All right. I'm supposed to be like semi-professional here. Plaintiff's request was the same as request 4, but with regard to plaintiff Robert Shin, defendant had the same response as 4. Plaintiff's rationale is the same in request 4. Defendants must produce some copies of all social media posts they've made about Robert Shin from January 2020 to present. Plaintiffs requested all social media posts regarding Melanie Wilkin and her affiliates from January 2020 to the present. Defendants objected as Melanie Wilkin is a non-party. Defendants' objection did not include any legal reasoning for how seeking information relating to a non-party to a lawsuit is a valid objection. Information related to non-parties is discoverable information. Defendants' posts indicated that she'd been in contact with Melanie Wilkin and other associated with Miss Wilkin in relation to posting about the plaintiffs. As defendants' own statements have related Melanie Wilkin to the core factual basis in this lawsuit information and communications regarding her is highly relevant. Defendants must respond to this post. Oh, Bo, I'm going to have to go back a little bit here. Bo, have a look at this. As to the defendants' claim they do not know what affiliate means, the dictionary definition of affiliates is yes. She's saying she didn't know what affiliates means, and 7M's lawyers not only given them the definition, but has given shade to the other side to say, well, you're supposed to be an experienced litigation lawyer, and you don't know what affiliate means anyway. So plaintiffs have requested the same as 4 and 5 in relation to Derek and Miranda and James Derek. Defendant's response is the same. So they're saying the rationale's the same. Plaintiffs requested defendants produce all drafts of social media posts. Defendants have made about 7M films, including defendants objected on the grounds of relevance. Defendants have engaged in a campaign of false information against 7M Films, Inc., almost exclusively consisting of posting to social media. All drafts, notes, communications, and other preparation materials are relevant to this lawsuit. Unposted or posted drafts are relevant, as they allow the court to gain clean information as it relates to the factual accuracy of defendants' posts, as the intention of defendants in posting them. Further, the evidence of drafts outlines and such other documentation or information can be used to determine if defendants are considered journalists. As the information is relevant to this lawsuit, defendants must disclose. Plaintiffs requested defendants produce full draft social media posts of Robert Shin, and they objected to relevance. Well, she always talks about affiliates all the time. And then plaintiffs requested all correspondence in which defendants discuss 7M Films and its affiliates with third parties. Defendants objected as material protected by journalistic privilege. Plaintiffs incorporate their previous analysis of the journalistic privilege here. Defendants do not qualify as journalists and therefore are not entitled to journalistic privilege. I mean, let's face it. To say you don't know what affiliate means. Notwithstanding, the privilege asserted does not prevent from discovery of relevant information as it relates to all third parties. Journalistic privilege is narrowly applied to sources of information to journalists, not all persons whom a journalist contacts regarding an issue. See Cervantes and Times. Further, if the defendants were themselves a source to a legitimate news organisation, they do not qualify as a journalist, but a source and must disclose the information. Defendants are required to respond to this request, which is really interesting. If they can prove that it was Katie Joy that gave all the information to the other outlets, she's not covered by journalistic privilege. That's not covered by journalistic privilege. So they did a repeat again, same thing. Again, they've used the same defense. So essentially, 7M's filing a motion to compel discovery, believe it or not. So that's the same. Plaintiffs have asked for tax documents from Catherine Mansky-Polson from January 2020 to present. The defendants objected to relevance. Didn't she want all the tax information of Shin? Defendants have a self-proclaimed monetized social media presence. The subjects she discusses on her social media page and what brings in revenue. If defendants have sustained an increase in revenue as a result of their disparagement of plaintiffs, that monetization is relevant to defendants' motive for their continued assault on plaintiffs' character. As for tax returns and other financial statements are relevant to this lawsuit, defendants must disclose the same. So then they've asked for tax documents for without a crystal ball. They've objected to the same. Plaintiffs requested all contracts defendants have entered into with third parties regarding plaintiffs and the Shekinah Church. Defendants objected as irrelevant and that the contract contained confidentiality clauses. Okay. Defendants have failed to provide a legal basis which supports the contention that a confidentiality clause in a contract would preclude discovery in a lawsuit where there has already been a determination that the parties may elect to assign confidentiality to documents disclosed. If further, in response to interrogatories, the defendants claimed that they were unaware of anyone who they would have made contact with regarding plaintiffs and that they did not keep such records. If defendants do in fact have these records, it appears that the defendants have lied under oath in their discovery responses, which constitutes perjury. With regard to relevance, one of the male claims of plaintiffs is that the defendants have alleged that they say that they and the Shekinah Church are a cult engaged in heinous criminal acts. Any contracts defendants have entered into with regard to this church are extremely relevant to the defendant's motive in this lawsuit, as well as the discoverability of the underlying factual basis for her statements. Defendants must respond to discovery requests. And again, they want contract. I know we're getting with Amber has not. She's gone in hard here. So again, rationale here. So again, they're talking about journalistic privilege. It's interesting. Plaintiffs requested all communications regarding the production of a HBO documentary regarding plaintiffs. Defendants objected to journalistic privilege. As previously outlined, defendants are not journalists, and this information is not protected by the purported journalistic privilege. Further, the journalistic privilege in both Minnesota Statute 595 and Cervantes only extends as a one-way protection of journalists revealing their own sources. They do not allow persons providing information to a documentary company from disclosure. As defendants have given information to HBO or its affiliates for the purpose of creating a documentary, it is assumed that the contract had some sort of monetary consideration to defendants. Defendants are potentially gaining monetarily from this documentary, which goes to the defendant's motives about posting about the plaintiffs. Further, the conversations and correspondence given by the defendants to the documentary are extremely relevant, as plaintiffs are entitled to review the nexus of information between what defendants were told from their sources to what they stated on their social media platforms, as well as what information they gave to other journalists or documentary creators to report. The basis of the plaintiff's claims rests on the defendants creating false information and stories about plaintiffs, information which proves that is both discoverable and relevant. The extent of which defendants spread false and defamatory information is not only relevant to, but the entire point of this lawsuit. As such, defendants are required to answer this request. Plaintiffs requested all communication about the next. Yep, they rejected it. Same. Now we're still into interrogatories. So, interrogatory plaintiffs requested defendants identify each person they are aware of who may have had knowledge or is likely to have knowledge of discoverable information relevant to the facts and circumstances of this lawsuit. Defendants objected on the basis of journalistic privilege. See prior discussion. They've requested all facts which support each denial in defendant's answer. Defendants objected on the basis the interrogatory attempts to expand the number of interrogatories. Defendants have provided no law to support that is a valid objection. Further, the answer to this interrogatory could be the same if we asked for a specific denial or for all of them. Defendants must reasonably answer discovery requests pursuant to the rules of civil procedure. Requesting identification of facts which support the denials in the defendant's lawsuit is the most basic principle of discovery. The basis of this lawsuit is that the defendant made up lies about plaintiffs and it caused them harm. Requesting discovery to show defendants' claim that they did not make up the statements that they made about the defendant is relevant. Defendants must answer this interrogatory. You're right. Well, she was saying that she was going to win the lawsuit because he hadn't done anything. Because she hadn't done anything. She was saying she was going after that Shin hadn't done anything. So plaintiffs requested that each statement defendant had made about a person, and they objected to this being overly broad and unduly burdensome. Plaintiffs provided a specific time for which each defendant needed to provide instances where they shared information about third parties, including but not limited to the plaintiffs. Defendants have been the subject of numerous lawsuits for false and unverified statements about third parties. The total amount and frequency of the statements for which the defendant have made false or unverified statements is highly relevant to this lawsuit. If this interrogatory is overbroad and unduly burdensome, it is only because the defendants have a regular habit of making false and unverified statement of fact. Touche. Wow. Oh, dear me. She's going in for it. She's gone in hard. Defendants are required to answer this interrogatory. Plaintiffs requested the number of followers purchased by the defendants from January 2020 to present. Defendants objected as to relevance. This lawsuit is based on defendants' false and defamatory statements and dissemination to their followers. Defendants have claimed that they are a journalist instead of a social media personality. Purchase followers are relevant to defendants' claims status as a journalist, as well as to the extent of their of her false and defamatory statements about plaintiffs. Defendants are required to answer this interrogatory. So now they said they asked for the name of the address of who provided defendants with information. And so she used journalistic privilege. Again, journalistic privilege. Plaintiffs requested information regarding Melanie, Kelly and Dean Wilkin. They objected on the grounds they are not party to the lawsuit. And then there was a discussion about Melanie Wilkin before. And that she included numerous references to her communications with the Wilkins. Further, defendants had a hyperlink which connected to the Wilkins social media. Oh dear. At the start of her campaign against the plaintiffs, as Miss Paulson has clearly had significant and continued contact with the Wilkins, and it appears much of that information has been shared by Miss Paulson with third parties. It is extremely relevant to this lawsuit and must be disclosed. Again, journalistic privilege. What information was provided to defendants supporting statements? So plaintiffs asked what information was provided to the defendants supporting their statement 7M Films and Robert Shin are involved in human trafficking. Defendants objected based on journalistic privilege and plaintiffs' paraphrasing words. Defendants further provided a couple of court cases and stated various social media posts published by interested parties and news articles by other journalists. See prior discussion. Plaintiffs in their summons and complaint have alleged defendants stated that Robert Shin and 7M Films were involved in human trafficking. If this statement is a paraphrase, defendants are required to answer and state that or deny that they made such a statement. Plaintiff did not request what court files defendants reviewed. The interrogatory asks what information was provided to the defendants. The defendants are fully required to answer this interrogatory with what specific information was provided to the defendants regarding plaintiff. Defendants' answer various social media posts published by interested parties and news articles by other journalists is evasive and incomplete. And again, what information was provided to them to prove that 7M is a cult? So 7M said, how have you come to this determination that 7M is a cult. What information have you based that from? And she's saying journalistic privilege. So then they've asked, interrogatories 1924, plaintiffs asked what information was provided for the following statements. The worst part of this cult is that they are preying on black dancers, exploiting them, then making them believe everyone is mad at them because they are black. Robert Shin essays women. Robert Shin is instructed by God to teach young women about you know what, and that he induces them into joining the cult. 7M are under mind control. Dancers are told and believe that they are anointed by God. The source alleges Robert has brainwashed them to believe outsiders are not worth of their time and dangerous. Social media managers at 7M Inc. are blocking any family member and friends from trying to reach out. Defendants copy and pasted the same objection based on journalistic privilege as a response to each. So at the moment, we've still got unverified baseless claims or statements that's been made. Plaintiffs requested that the information provided to defendants which support their statements that leaders threatened to kill their families if they kept in contact them. Defendants objected on the basis plaintiff's amended complaint did not make this allegation. Plaintiff's amended complaint referenced all posts passed during the course of this lawsuit. As defendants have continued to post false and defamatory material regarding plaintiffs, all material is relevant. If defendants claim they did not make this statement, they may state they did not make such a statement. However, as the interrogatory asks a question about a statement defendants made about the plaintiff is relevant to this lawsuit, and they must answer. So then we've got here some more that they've answered. Your pastor has openly admitted that he curses people that do not donate him. There's the water, let you have a read of that yourself. See prior discussion with defendants purported journalistic privilege. Defendants are required to state what specific information was provided to them for each of these statements, as well as the person who provided them. Plaintiff requested for reasons for each of defendants' affirmative defences, and they objected on the basis it was a legal conclusion. This is not a valid objection to an interrogatory. Interrogatory otherwise proper is not necessarily objectable merely because its answer involves an opinion or contention that relates to fact or application of law to fact. This question asks defendants to explain their reasoning for their affirmative defences using application of law to fact. As defendants, they must answer this interrogatory. Interrogatory 46, plaintiff asks for the factual basis and reasoning for defendants' denials in their requests for admission. Defendants objected on the grounds that it would expand the number of interrogatories. Defendants have failed to provide any legal basis for this objection. So they're saying defendants have failed to provide relevant and discoverable information. They failed to outline a legitimate legal reasoning for why they can't respond, and as such, Plaintiffs' Rule 37 motion compel full responses to discovery must be granted, and cost disbursements and affirmative attorney's fees shall be paid by the plaintiffs. Right, so that is, there's still more. I mean, we're not even halfway through yet. To be fair, we're not even halfway there yet. All right, so I've got to go back because it's taken so long for that we've got to go back. That was really bizarre. So essentially she's used, we can't give you that information because it's journalistic privilege. We can't give you that because it's not relevant. We can't give you that because it's going to make it longer. Which essentially means that she's not answering the question, correct? All right, so we've got that one. Now we've got a so we've just done the memorandum. Okay, then we've got to do, all right. This is the memorandum. This is 2 pages. We did that one. That's the 2 pages that on the first, that there was going to be a notion, yeah, that they're going to do a motion to compel. We've had the substitution of counsel. Right. Next one. All right. So then we've got, affidavit of attorney. Can you see why she's been spiraling out of control? I think I just saw plan and create, plan to create. Just jump in. Hello, plan to create. How are you? So I'm just going to open up these ones here now. Just give me a minute. All right. Let me just pull this back up. Well, see, that's the thing. If her financial records aren't relevant, why is his medical records relevant to her? All right, so this is her affidavit. So her exhibits are here. That she's done it in good faith. So that's the cover of the affidavit to say that Exhibit A, B, C are true and correct copies. Okay, so we've got that. So then we've got other document here. For some reason, it doesn't open in the same window. It opens in a completely different location. There we go. Let's look at this one. All right. Oh, this one is interesting. Now, I don't think all of the documentation is actually here. I think some of it is actually hidden, which is how it's supposed to be, which I believe is what's supposed to happen. Okay, so we're going to share this screen. So this says, for plaintiff's first set of interrogatories, so this has been refiled. This is, please take note. And so this was filed unless concludes in negated. So this is telling you about, this gives out the definitions of what they are expected to do in the interrogatories. All right, they're just redoing it. See, identify each person defendants expect to call it a trial. Say all the names. So this is what they're saying they provided to Katie Joy as to what they wanted from her, and this is what she's failed to provide. She's provided some, but not all. Okay, this was filed on the. Okay. And so if you put that toward with her letter, you'll see where she said, you know, I think 19 was in there. Oh, yes, that's right. What information was provided to you supporting your statement which maintains that Robert Shin is instructed by God to teach young women about the birds and the bees, and that he induces them into doing for each fact statement, please provide the name and contact information for the person who provided the information. Well, that's what 7M's wanting to know. How has she come to this conclusion that he's a cult leader? And that's what they're asking the court to do. They're saying to the court, she's saying this, but she's not prepared to actually tell us how she's come to this conclusion. How does she get to this conclusion? How is this conclusion justified? Yeah, and it's. So the next lot of documentation, I'm just going to show you this main screen again. Is it looks like there's stuff in here that we can't see, right? That aren't made public. So there could possibly be some confidential stuff in there. That is just another set of interrogatories. They look like that they're interrogatory documents, so, you know, where they've requested information. Right. Then they've got their objections. All right, let me go here. Let's have a look. This is interesting. This looks a bit interesting. So then we've got their answers here. They've filed their answers into the court. Let's have a look. It all comes down to whether or not she's deemed a journalist. So it says to plaintiffs, so here it says the interrogatories here. Here's their answers. State specifically and not in general fashion, name, address and phone number of all individuals who help you prepare your answers to interrogatories, requests for production and reasons for admission. Catherine Mansky-Polson, Counsel of Record. Oh yeah, so here's their answer. This is her answers here. So they've filled this in. Objection, journalistic prisma, identify each person defendants expect to call as a witness at trial. It says unknown. What experts? None as yet. Identify each every document defendants intend to utilise. Exhibits have not been identified. Defendants declined to respond. State the name of all social media platforms. There's the YouTube. Holder Catherine Polson and without a crystal ball. Username without a crystal ball. Email address. Twitter. Hey, look, there's a Twitter handle. Instagram. Facebook. Isn't there also TikTok? So state the names and addresses and contact information for any and all employees, contract workers and other contributors to Without a Crystal Ball. Catherine Mansky-Polson, Mr. Polson's husband, helps out on back office issues from time to time but does not post material on social media. There we go. It's there. So there's the objection. So this is what they've responded to. So they objected about the human trafficking, as this may not be a fair paraphrase of any statement defendants have made. That's what she said. Oh dear. So they've just used the same objections over and over and over again. Oh, what's that one? Okay, so this one was, it may not be a fair paraphrase of the statement that they made. It says, defendants specifically point to the Instagram post located at Katie Joy on Instagram. Shekinah Church demands members include them in all emails through blind copy, meaning the recipient cannot see that Hannah is reading, which contains a reproduction of an email sent from Hannah Grace Lee. Finally, statements that the defendant may have made are statements of opinion based on cumulative reporting that is protected under the First Amendment to the United States Constitution. You can't use opinion and then say that you are reporting in the same sentence. Either you've given an opinion or you're reporting facts. Both can't be true. Am I correct there? Or am I going totally up the garden path there? Because I would think you're either giving an opinion or you're stating fact. Then they've put in all the then they've put in all the other correspondence that they've sent to them. Yeah. So, this is just, I just find this really bizarre. I have to tell you, this is really bizarre. I'm just struggling with all of this. None of this is making sense, particularly when they've said we don't know what an affiliate is. So this is a proposed order, okay? This is not an order. This is what they want the judge to agree to. So I just need to state that. Okay, this is a proposed order. It says proposed order. It's in brackets. Proposed. All right, order. So they said that they want the judge on the 1st, that on May 11, 20... Oh, that's interesting. That's wrong. Was served with plaintiff's first set of interrogatories, requests for production documents and requests for admission. On the 12th of June, defendants served their answers. On the July 7th, plaintiff served defendants with a letter outlining their discovery deficiencies. They were required to participate in discovery relevant to the lawsuit at hand. Defendants have failed to respond. The court finds defendants have failed to respond. The plaintiff's motion to comply is granted, and that the fees are paid by her, and then the judge just signs it. So that's what they're wanting. Well, this is the thing, Will. She can't make up her mind, and that's the thing. She flits and floats according to whatever floats her boat on the day, and you can't do that. You're either a journalist, and that's not to say that journalists can't write opinion pieces, because they can, but opinion pieces usually have the word opinion. Okay, so this was another letter. Defendants object to plaintiff's interrogatory and each definition and instruction contained therein to the extent that they purport to impose obligations different from and beyond those imposed by Minnesota Rules of Civil Procedure. Defendants object to each interrogatory to the extent it seeks information and documentation that is not relevant to any party's claim or defence, in unduly broad or overly burdensome, which requests production of information disproportional to the needs of the case, or which involves information to which the plaintiffs already have access from a more convenient source. So essentially she's saying, I don't want to have to share with you. I mean, is she doing this because she doesn't have any of the stuff? They object to each interrogatory to the extent that it seeks that is subject to the attorney-client privilege, work product doctrine, or the privilege or immunity on the grounds that privileged material is exempt from discovery. Defendants will not produce any privileged material. They object to each interrogatory to the extent that it is vague and ambiguous. They object to the extent it seeks information and documentation that is not within the defendant's possession, custody, or control. They object in the absence of it to a specific objection to a request shall not be construed as a waiver of general objections. Defendants do not waive any of their general or specific objections in the event that they furnish information or documents coming within the scope of such objection. Discovery is ongoing and continuing in this matter, thus the answering party expressively reserves the right to modify, supplement and amend these answers should additional information come. Additionally, by responding to these interrogatories, the answering party is not waiving or doesn't intend to waive, but expressly it reserves its right to assert at any time during this litigation all objections raised. With respect to any interrogatory that indicates the defendant has made certain statements on social media, defendants object insofar as the posts speak for themselves. So is she saying that those posts are correct then? But just because you post something, you've still got to be able to show how you got to that conclusion, don't you? It's like in a maths exam. You can write down the right answer, but they want to see how you got to that answer. Oh yeah, we did that, didn't we? We've looked at that. I noticed that TikTok's not there. And she didn't put down her sock Twitter account because she admitted the other day that she's got a sock Twitter account. She's not on there. Yeah, so she's put all of this in here. So yeah, this is yeah, she wants to be taken. Of course, she wants to be taken seriously. Defendants can only answer generally. Documents also reviewed court files, various social media posts published by interested parties, and news articles published by other journalists. Will submit them. Finally, statements that the defendant may have made are statements of opinion. Yeah. So show this is what I read, this is what I read, this is where I got it from. It says, what information was provided to you supporting the statement that leaders threatened to kill their families if they kept in contact with them? For each objection, the amended complaint does not allege defendants made this statement, and a citation is necessary to answer interrogatories. Oh, wow. So this is, how can you prove that you, and they've said, well, we reviewed social media posts by other journalists. Again, prove it. And why? Why was she reading court documents to find out whether she, why was she reviewing court documents about whether she made a statement about that? What information was provided to you supporting your statement that each church members are not allowed to drive or own or drive cars? Objection. So it says defendants also reviewed court files. But as I said, why? And then she's saying, finally, statements the defendants may have made are statements of opinion. Well, then, are opinions covered under general? Oh, here's the question though. If then what is you're saying that it's here's the question. Here's the $60 million question. Here it is, all right? Can statements of opinion be covered under journalistic privilege? That is, I think, the question. A statement of opinion. When it was, and here's the other thing. The next question is, was it clear that, was it clear at the time that the statements made were opinions, or were they taken as statement of fact? There's your $60 million question. And that is what, I think this is what is at the issue here. So you can't play the journalistic privilege card on one hand and say, but it was my opinion on the other, because they don't come into play. Because if you've made them, if they've come across a statement of fact, then you actually have to show how you got to that conclusion of statement of fact. I think, yeah, well, that seems, and here's, and look at a lot of the stuff that she's doing now with she's digging up in the past of all these other people. She's so busy digging up the past that people could have changed, and there could be so many different things happening at the moment, right, that aren't even relevant to the past. I mean, just everybody has a past. Everybody's done stuff foolishly in their past. And how would you like it that if that just kept being dug up and dug up and dug up, and you're not able to move on because you can constantly... I mean, she talks about how she wants her past not to be discussed and stuff that she's done in her past. Well, the same rules have to apply, don't they? So even if they are facts, they're not the subject. This is the thing. A lot of that is not making any sense, and that's the issue. I can't make head or tail out of it. So, and the fact that she doesn't know what an affiliate is probably even more of a concern. Anyway, I have got some stuff to do. I've got to try and I'm going to try and sort out some stuff for uni and work out what my next steps are. I will catch you again later. Thank you for watching me. I hope that's answered some questions. So, yes, so as Katie Joy was saying, she's winning. So she's winning, as she said, and she's determined it's not going to go to trial, but the only way it's not going to go to trial is if she settles. So, oh, I just loved that. That was hilarious. Anyway, if you could do me a favour, hit the likes and subscribe button, and look, I've listed below different ways you can support the channel. If you can support, that would be great. I can keep bringing great some content to you. But otherwise, thank you. I hope you have a great day, night, wherever you are in the world, and I'll catch you.